and I was told in a letter that the petition would be considered the motion until I get it there, and that was well past.
Well, they
date.
might dispute that, but I mean, I kind of did treat your petition as notice that you were.
A fax notice up at the top. I believe that's what they're using as.
Yeah, I can't read mine, so.
It's November 6th.
Tonight's case opens with Mr. McMillan, self-represented, trying to undo a signed paternity acknowledgment. Miss Jackson appears, DCF joins, and the clock matters. A single document could mean 18 years of support. Stick around for the twists ahead. Subscribe, like, and share for dramatic breakdowns right now today, everyone.
In person and self-represented in a paternity case he filed in 2025 DM 337. Ms. Jackson appears. Ms. Jackson, you came to the courthouse?
Yes, I did.
Okay. Where do you live?
Andover.
Thank you for appearing. And we have DCF represented by Ms. Hawks. All right. There is a corresponding child support case in 25 DM 186. It's this court's opinion that the motion to set aside the VAP could have been filed there, or in a paternity case. So Mr. McMillan brought his own paternity case where he's disavowing or trying to rescind the VAP. It isn't to establish that he's the father, but rather that he's not the father.
Correct.
He is on the voluntary acknowledgement for paternity. And in your petition, you indicate, or in your motion, I should say, to set aside that you filed. You indicate that the acknowledgement of paternity was within 1 year of your request to set it aside. But I don't have a copy of it. DCF has access to it. You have access to it. DCF has access to it by statute, but I don't have it. And I thought I had requested that you send us a copy of that so that I could, I assume it's right around the time that the child was born, but so that I could confirm the date that you executed that.
Executed are you talking about the final motion or my forms that I sent in earlier? Because I was told in a letter that I got from your assistant that the forms would be that were received would be good enough to go along and start the court filing procedure, and I just needed to turn in a final motion to have it on paper. I was emailed by your assistant, Amy, a while ago. I can check the dates that you guys did get the final motion. And so so what paperwork are you referring to that you do not have?
The actual acknowledgement that you signed at the hospital as
okay. Yes, no, because there was none. I specifically asked the delivery nurse for a paternity acknowledgement form and a DNA test prior to the child even being born in the hospital room. I was then told by the delivery nurse that they do not do neither of those two legal documents in the hospital, and this is at Wesley Medical. The only thing I did sign was the birth certificate, which under my what I've been told is not a sign of paternity establishment.
Your Honor, if I may,
Yes.
I have a copy of the signed voluntary acknowledgement of paternity. I apologize, I had not provided it because it was my understanding today was a pretrial conference, but I'm redacting the confidential information right now, and I'd be happy to email that over to Ms. Spokman if you'd like to see a copy of it today.
Yes.
I will get that emailed in just a moment, Your Honor.
Is that Amy? Can that be emailed to me also?
I can email it to both parties, Your Honor.
Yes.
Yeah, thank you. But yeah, what I said in the hospital, I did ask for a paternity acknowledgement form and was told that was not what Wesley Medical provided. So I'm not entirely certain what piece of paper she's referring to.
Well, you being on the birth certificate does create a presumption under the law, but when you actually sign an acknowledgement, then that has greater force and weight unless it's challenged within a year. I mean, you're really excluded from being able to challenge it at all if it's been after a year.
Well, I sent in my I don't have my paperwork with me right now. I'm at work, but I sent in a bunch of forms requesting paternity testing and denouncing paternity.
Yeah, I have that. I have that in the court file. I just don't have a copy of the VAP, which is the voluntary acknowledgement of paternity.
Oh, okay. Okay. I don't either.
Can you send that, Amy, to my Gmail, please?
Your Honor, I just hit send on the email to Ms. Spokman, and then I will send it an email now to Mr. McMillan and Ms. Jackson.
Okay. Mr. McMillan, where do you work?
I work for my brother. It's called the Sign House in Salina, Kansas. My brother is Robert Harper.
Mr. McMillan, can you remove your hats, please?
Yeah, I'm sorry.
Okay, so Mr. McMillan, have you gotten the VAP?
I will check.
I'm about to hit send on his email, Your Honor. I was sending them separately.
Okay. It looks like it was executed 9/10 of 2024.
So while we were still in the same in Wesley. So yeah, I specifically asked, I have to look at this because I did ask the delivery nurse about the paternity acknowledgement form.
Well, I mean, you executed one. So unless you're gonna, establish there's a forgery, you have in fact executed one. And so this petition was filed on the 8th of September, not the motion, but the petition.
And I was told in a letter that the petition would be considered the motion until I get it there, and that was well past.
Well, they
date.
might dispute that, but I mean, I kind of did treat your petition as notice that you were disputing. I don't see a filing date of your motion, unfortunately.
Your Honor, I believe it was filed on November 6th. There's a fax notice up at the top. I believe that's what they're using as.
Yeah, I can't read mine, so.
It's November 6th.
Okay. So what is the state's position on the VAP and by virtue of filing the petition on September 8th with regard to his ability to contest the VAP within 1 year.
Your Honor, I mean, I believe I knew what his intentions were on the September 8th filing, that he was intending to set aside the voluntary acknowledgement of paternity. So I'm not necessarily asking that he be barred from making any argument because he titled the document a petition versus, a petition for concerning paternity and opposed to a petition to revoke the voluntary acknowledgement of paternity. However, I mean, I think he still has the burden, and it's on him to prove that he signed that voluntary acknowledgement of paternity based on fraud, duress, or material mistake of fact.
Here's the legal pivot. The voluntary acknowledgement carries real force. Filed within 1 year, he's not time barred, but the burden flips onto him. Fraud, duress, or mistake must be proven. Do you think exhaustion excuses a signature, or does paperwork rule under this statute today? Here, folks watching closely.
So I did look at the paperwork. I really don't remember that. It was after, but I will say it was after 24 hours of her in delivery, and then she went into a C-section. At the time of signing, I hadn't slept in 36, maybe 48 hours.
I mean, that you're presumed to know what you sign. So,
and I did ask the delivery nurse about a paternity acknowledgement form, and they said they did not do that. So
well, they obviously do. The social worker must have came in. Somebody brought in this form because you executed it. So we need to set this for trial. I have not looked at whether the burden of proof is clear and convincing or a preponderance. Does it indicate in the statute?
Your Honor, the language says the person requesting revocation must show and shall have the burden of proving that the acknowledgement of paternity was based upon fraud, duress, or material mistake of fact, unless the action to revoke the acknowledgement of paternity is filed before the earlier of 60 days, which obviously was not filed 60 days after he signed. I don't see if it's preponderance of evidence or clear and convincing. I can do more research, Your Honor, to determine that.
Okay, because the burden of proof matters. I mean, he has the burden of proof. The standard of proof is what we need to clearly establish.
So you need proof on why I think this is not my child.
No,
No.
look at your motion you filed. By statute, read the statute.
I currently forgot my paperwork at the house.
Okay, well, we're not doing it today anyway. I'm going to
Okay,
schedule it for an in-person evidentiary hearing. But you have to prove when it's greater than 60, but as long as it's under a year, which you've met I'm finding that you've met the under a year. Not only did you orally contest paternity in your 25 DM 186, but you subsequently filed a petition in 25 DM 337 and then followed up with a formal motion. So I'm not going to find that you're time barred for the 1 year to be able to challenge it. So you have succeeded there, but then what you have to do is you have to prove that you signed that document under mistake of fact, without full knowledge of the relevant circumstances, and so that it constitutes some form of fraud, misrepresentation, etc. Okay.
Okay.
So
okay. I'm sorry.
that is what you have to prove. I would strongly recommend, if you truly do not believe that you are the father, then I would strongly suggest that you try to obtain an attorney because it's going to be cheaper to pay an attorney now to help you proceed with this case than 18 years of child support. So you make the decision, but you're going to be acting as your own attorney. You definitely have the burden of proof, and you have to prove fraud, duress, or mistake of fact, or that document is a full-fledged forged document.
I
That's
mean,
the way the law works.
Okay.
The law wants to establish fathers, and the law doesn't freely allow, once a person has legally acknowledged paternity, to just rescind that. So that's just the way the law is stated and the way it works. And so I'm going to give you enough time to prepare your case and subpoena your witnesses and do whatever you think you can do, your own testimony, any exhibits you have to show
Yes.
fraud, duress, or mistake of fact. Okay?
yes, so I do have a it's all electronical evidence that would back my theory on why this is not my kid. The other person texting the defendant or
Okay.
other.
So you're not proving that it's not your kid.
Wait for that moment. He insists no hospital form existed, yet the executed acknowledgment appears dated September 10th. The contradiction lands hard. The judge is clear, signatures count unless forged. Claiming confusion after the fact raises eyebrows and tension spikes across the courtroom instantly as everyone listens, stunned, quietly breathing.
What you have to prove is the document that you acknowledge that it was your child back on September 10th of 2024 was signed under a mistake of fact, fraud, or duress, or some form of misrepresentation.
Down right at the door, so you can hear.
Okay, that's what you're proving. Then if the acknowledgement gets set aside, then the court can decide if it's in the best interest to order genetic testing per your request.
Okay.
Which the child's young enough, quite honestly, I probably in holding the Ross hearing would take into account those factors. So we may get there, but you legally have to present sufficient evidence to set aside this document that you apparently haven't fully looked at.
I just looked at it. My initials. I mean, it's
Okay.
so yeah. They're,
All
they're
right, I'm going to set this for an evidentiary hearing. Again,
All
I
right,
would
all right,
strongly,
can I get a court appointed lawyer?
no,
appointed by court? No.
no, not in a domestic case, no. Because you're not going to go to jail over anything. So no, you're not entitled to the appointment of counsel. Ms. Hawks, do you think that we ought to have a specific pretrial order, or are you satisfied with just scheduling this for a trial?
Your Honor, I'm fine with scheduling it for a trial. I think there's pretty much one very specific issue. I don't know that a pretrial order would be necessary.
Okay, okay. So if you're going to subpoena witnesses and or talk to an attorney, today is the 24th, you need at least 2 to 3 weeks to subpoena witnesses. I actually think either the afternoon of January 8th or the afternoon of Friday, January the 9th would give you enough time.
Yeah, it's the time's not the problem. It's more like the money. I've talked to many lawyers. And a retainer fee is $4,000, and I don't have that money. I don't know.
Keep calling.
I mean, that was the lowest retainer and I have called 3 counties worth of attorneys. Butler County, Sedgwick County, and Saline County. I have called every lawyer that will pop up online. The lowest retainer fee is $4,000. I don't have that.
Okay. Well, I don't know what to tell you. Contact legal aid then. And see if there's somebody from legal aid that would represent you, or if they would give you some references that people that do reduce fees or don't require a big retainer. So contact legal aid, see if there's some association that provides some advocacy group. I think you ought to try more attorneys. They're going to need, though, that VAP and any evidence that you have. But most of them will at least consult with you for an hourly rate to consult with you. So I'm going to go, and they can continue the trial if they need more time or you need more time to pay or whatever the case may be. But I'm going to get this scheduled for trial. That's all I can do, sir.
Judge, I will say on January 8th, that is where we have the probate trial with Miss Henry, Miss Sir, and Mr. Elliott scheduled from 9 to 5.
Okay, it's not in my book.
It's not.
All right, so, well, that's not going to work. And that's backed into backed into a Greenwood week. That probably wasn't very smart.
Correct.
All right. I don't know that I want to turn around and have another trial January 9th, but this case has to be heard.
And the 9th, you've got a 9 and 10 pre-trials on civil cases, and then we just have a name change at 1 o'clock that day, but I could move it.
Okay, that's not on my calendar either. No, I don't want to move that. Well, we could do the morning of January 23rd. And that means we'll just be limited on that domestic day. You're just gonna have to find some place else to put some of the domestic, Amy.
Okay, the only hearing that we've got scheduled that day outside of first appearances is at 11 o'clock, and it's a case that I moved due to the Coley sentencing. And I believe
I don't have that on my calendar either. Okay, so Ms. Hawks, does Friday, January the 23rd, of course, that's child support enforcement on Fridays, isn't it?
Your Honor, Judge Murphin is the 1st and 3rd, so I believe that's the 4th Friday, so I should be available.
Okay. Do you want to do 9 to 11 or do you want to do 3 to 5?
I would prefer 9 to 11, Your Honor.
Okay. All right. So, sir, you have 2 months to get your case put together. Go online, go to YouTube. If you've got to represent yourself, figure out how to do it, subpoena witnesses, look at the statute, read whatever you can come up with. That I cannot give you legal advice, but that gives you 2 months to either secure counsel and have them ready to go, or entered in your case as your attorney, or ready to try the case. Okay.
All right.
So that is Friday, January 23rd. I would suggest that you print that document out and that you have it available. Ms. Hawks, do you believe that that should be filed under seal in the court file, or just
Your Honor,
the record in the trial?
Your Honor, I did redact any of the confidential information before I emailed it to the court and parties. I'm always partial to filing anything like that under seal, but if somebody objects to that, that's fine as well. And if Mr. McMillan or Ms. Jackson either obtain counsel, I would obviously be happy to send them a copy as well.
All right, sounds good. I think I'll just make it part of the trial record at this point. It could have been probably attached as an exhibit to the motion, but I don't think he's gonna figure out how to go back and do all of that. So, I think that as long as everyone has it and understands that that's gonna be an exhibit, in the trial, then and part of the record, I think we'll be okay with that.
Yes, Your Honor, and I had intended to admit it as an exhibit at final hearing, so.
Sure. I mean, I think it's gotta be. All right. 10 days prior to the trial date, I want you to provide a list of witnesses and a list of exhibits to opposing counsel and to the court. Okay, so that would put,
And how would one go about doing that? Do I send it? It's electronic. Do I send it through email? Would I send it to your assistant?
you can print it out and mail it to the clerk of the district court, or we get notice of everything that you file.
Yes, so I have an audio recording of the mother admitting to selling herself for illegal drugs on conception date. It's an audio recording, ma'am. And the drug dealer texted her and asked if it was her child, and her response was, "I don't know." I have a screenshot of it, Your Honor. An audio recording.
Okay, well, you're going to have to authenticate it by calling her as a witness, seeing if you're gonna have to research how you're going to introduce that into evidence, and you've got to provide it to the other side. So Ms. Hawks is prepared to know what the evidence is going to be, as well as Ms. Jackson has a right to know what the things are that you are going to present. Okay? And then you've got to get it admitted, which is why I'm telling you that it is a very good idea for you to secure an attorney, even if you
Yes.
have to get a loan from somebody, because you're going to be paying a lot of child support for the next 18 years. I think it's more important for a child to know who their father is and for a child to be involved in their life. But I'm just trying to impress upon you that you get one shot at this, and it's not that easy to act as your own attorney. Even if you're an attorney, it's not that easy to act as your own attorney. So witness list and exhibits need to be exchanged by January 14th. All right, if there's nothing further, we are adjourned.
Bottom line, the judge allows the challenge, sets an evidentiary trial, and warns the cost of losing could be 18 years. No court-appointed lawyer, heavy proof required. This fight isn't over. Like, comment, subscribe, and share for more shocking courtroom stories happening right here. Today, stay tuned, everyone, now.